Good evening. This is Rahul Reddy. Along with me is my business partner, Emily Neumann. We do live presentation on immigration updates every week on Tuesday at 5 p.m. Central Time. Along with me is my business partner, Emily Neumann. Emily, what do you have today?
Well, today we're going to give you the latest on the H-1B lottery, which is coming up next week. It's right around the corner. So we'll talk about how many petitions we're expecting to be filed and what are your chances of being selected this year. We'll also talk about visa stamping and how that works when you've had a petition approved. Is there any situation where the visa might not actually be approved? And the same thing for entry into the country. If you've gotten your visa stamped, are there any situations where you might not be allowed to enter the U.S.? And then we'll talk about priority dates. How do you retain it or port it to from one category to another, or from an old I-140 approval to a new one? And of course, we'll answer your questions live. I do want to point out that for those that are F1 students who are planning to file an H-1B next week, I am doing a free webinar. I have spots open on Thursday and Friday. This is just for F1 students about how to transition from F1 to H1 and what to expect during the lottery process. So if you'd like to register for that, I still have some spots open. You can go to immigrationgirl.com to get the link and register there.
Emily, you said that you have an estimate on what are the probabilities of getting in the lottery this quota. So I will ask you some questions, and I want you how you are coming to these conclusions. The first thing is that if I do have a master's degree from United States from a non-profit school, even if it's private, and it's from accredited university, of course we all know that we're going to fit into the master's quota. Now, if we do fit into the master's quota of the H-1B, what are the probabilities this year when we file in April 1st? What are the probabilities for them to get in the lottery?
So this is my prediction. Again, this is kind of a guess based on how many were filed last year in bachelor's cap versus master's cap, and what we're seeing this year, what we're hearing from other attorneys and employers. So my guess is about 70 to 75% chance of selection if you're filing in the master's cap. And that's taking into account that the lottery is going to be done differently this year, that they're reversing the order. So they're going to take the 65,000 first, and then those master's applicants that didn't get selected in the 65,000 will get a second chance in the 20,000 cap. I do also want to mention that I get this question a lot, what happens if they only select 60,000 or 65,000 and 20,000 for a total of 85,000? What if some get denied or withdrawn? Do those spots go empty? Do they have a waiting list? What happens in that situation? And USCIS actually selects extra petitions every year. They give them receipts. It's not like a waiting list. You'll actually be processed if you're one of the extra ones selected, because they know every year a certain percentage ultimately get denied or withdrawn. So last year was one of the first years we actually got data on that. They confirmed that they selected about 20,000 extra.
Wow.
Just in the regular cap.
Regular cap for 65,000.
Exactly. And then they selected about 7,000 more master's cap applicants. That means they were expecting to deny
25% of 25 to 30% of the H-1Bs, they're expecting to deny. That's dangerous.
Yeah.
Now, Emily, I just want to point out the experience that we have in filing the H-1B and why we give out these numbers. I know that we all know that people are very inquisitive. What are the probabilities of getting the H-1Bs? I mean, I have gone through the process of the immigration by myself. I know how it is. We started the office right on April 1st of 1997. So this April 1st will be 22 years we've been in business. And we've been filing the H-1Bs from April 1st of 1997 to right now, which is 22 years. So we've been filing. We did not have quota for a while because it was available and the lottery system actually started on April 1st of 2007. That's when all the applications have been received on one day. That's 12 years ago. And then 2008 also we had a lottery. From 2009 to 2012 we didn't have a lottery system. And from 2013 onwards we do have a lottery system until now. So based on our record and based on how much we file, and how much we speak with the clients. We are in touch. This YouTube, this Facebook that we have, and the daily conference call, and what Emily presents in her blog and on the webinar, we also get a feedback from you, and also we are also involved with the employers. Based on the feedback, we are coming to this conclusion of approximately about 75%, Emily? 75% for the, is it 75% you're thinking?
Up to between 70 and 75.
70 and 75%. That's what we're expecting in the master's cap. Now, if the people don't fall into the master's cap, Emily, this year's quota, based on our experience, what are the probabilities this year quota?
Yeah, I'm thinking you'll have about a 45 to 50% chance of being selected if you're in the regular cap.
Okay.
Looking at the numbers, so again, after last year's quota, we actually got the data going back all the way to, I think, 2013. Every year, the split between bachelor's cap and master's cap applicants. And since 2016, every year, bachelor's cap applicants has gone down, and master's cap applicants has gone up every year since we can remember. So because fewer are filing in the bachelor's cap in the way they're doing the lottery this year, I'm thinking 45 to 50% chance.
Even though the chances have gone back less, if compared to last year, you still think about 45. That's the expected for the bachelor's cap. Now, Emily, what are the options for those people? And when would we know exactly if one person's H-1B got selected in the lottery? Do you have a fixed date for it?
No, and it could be any time between mid-April to mid-May when we start getting those receipt notices. So typically, you know you're selected when your employer or attorney receives an I-797 receipt notice in the mail. And those start arriving in probably the third week of April, and they keep coming in until mid-May. At some point, we'll have an announcement from USCIS that says they've finished data entry and have finished mailing all of the receipts, and then within the next 2 weeks after that, we shouldn't expect any more.
So the process of receiving notices may start from April 2nd, 3rd week, and it may end up to July of 2019. That's the normal period that we have seen. And now we do have a premium processing, unlike the previous years. Is there a probability that is it required that they should approve the H-1B within 3 weeks after we file the H-1B application?
No, so the premium processing 15-day clock will start on May 20th. That means by June 4th, something has to happen on your petition. It either has to be approved, a request for evidence issued, or a denial. So by June 4th, if you file in premium processing, you should have some news.
Emily, what for there are premium processing for some H-1Bs, there are for the quota, and there are no premium processing for some. Can you explain which ones are eligible for premium processing, which ones are not eligible for premium processing?
Right. For filing the week of April 1st through April 5th, only those requesting a change of status can file in premium processing. Only your employer can file that application. It's not something the beneficiary or employee can do, but only those requesting a change of status, those are people that are already in the U.S. in another status and don't plan on traveling or exiting to get the visa stamp, those can be filed in premium. Everyone else has to wait until June, and you may have the opportunity to upgrade in June if you were selected.
So only those people who are in United States filing for the H-1B, and they are only filing for the change of status, they can be eligible for it. Can you explain what a cap gap is? Why June 4th is also important for those people whose STEM extension is expiring or OPT is expiring between now and June 4th? What should they do? Can you explain cap gap and also June 4th issue though?
Yeah, the cap gap comes up for anyone whose OPT or STEM extension is expiring between April 1st and September 30th. You're stuck in what's called the cap gap because your work employment authorization ends, but your H-1B doesn't start until October 1st, creating this gap. So back in the day, you just had to stop working, and you might even have to leave the United States and wait for your H-1B to be approved in that situation. But in 2008, they created regulations to ease the transition. So if your H-1B is selected and you have that receipt notice, and your OPT is expiring, you can take that receipt notice to your school, to your DSO, and ask them to issue you a cap-gap I-20. That should extend your employment authorization through September 30th with the hopes that your H-1B will be approved by October 1st to take effect. So for those, now there's the cap-gap I-20s are issued in 2 phases. One goes only to June 1st, the next one goes from June 1st through September 30th. The reason for that is if your OPT or STEM OPT is expiring between April 1st and June 1st, you might not have your receipt notice yet. So what are you supposed to do? And you don't have a rejection notice yet because those don't arrive until July or August. So everyone's kind of in limbo wondering, so they created this kind of phased in cap gap where if you don't have a receipt yet, but you can prove your petition was filed.
Like the FedEx tracking number?
Right. You can get a cap gap extension I-20 that goes to June 1st, and then in order to get the next extension to September 30th, you have to show up with your actual receipt notice. If you don't have a receipt notice by then, that's a somewhat good indication that you weren't selected. It doesn't mean for sure. The only way to know for sure is to get the returned petition back in the mail, but again, that doesn't happen until July or August. This creates a problem because the USCIS website and the regulations say the cap gap extension is automatic. You don't have to get that I-20 from your school. And on their website, it says you can keep working under the cap gap until the date of the rejection notice. Well, if you don't have your rejection notice until August, but your cap gap I-20 is only given until June, what do you do? It really at that point is up to your employer whether they're going to be willing to let you continue to work until the rejection actually arrives, or if they're only going to go by that I-20 because that's the documentation they need to prove you have that employment authorization. So it kind of creates a gray area there because the return of petitions process takes so long.
And for those people who are on student visas who are transiting into H-1B, I know you're very curious. You will have a lot more questions than we have addressed here. Please, there is a webinar that Emily Neumann is conducting it. You are allowed to participate in it and ask questions in it. You can check the webinar information on immigrationgirl.com. That's a blog Emily Neumann operates. It's immigrationgirl.com. So there's a webinar that we do conduct. Don't forget that we do have a daily conference calls that you can check at rnlawgroup.com, and you can log in our daily conference to ask questions. Emily, let's move the topic to a different topic on. You know, the visa rejection that happens in the consulate. A lot of people ask this question that the immigration, USCIS, has approved the H-1B typically, or maybe L-1 or different varieties of visas. And they get is there a chance that they can get the rejection in the visa after the immigration has approved the non-immigrant visa here in the United States?
Yeah, definitely. So USCIS's job when they're adjudicating the petition is to determine if the job offer qualifies and your education or experience qualifies you for that position and that it's a legitimate company and those sorts of things. So they're approving the petition, but then you still need a visa stamped in your passport in order to travel. So that visa interview process and going to the consulate is another type of adjudication. They're looking into everything again, even though USCIS approved your petition. If you get to your consular interview and the answers you're giving are inconsistent with what your company stated in the petition, that may make you ineligible for the visa. So that's one way that a visa could be denied even though the petition's approved. The consulate is also looking at, are you inadmissible? Meaning, is there something in your background that makes you not eligible to get a visa, such as some sort of criminal history, terrorism, DUI or something like that. So they're going to go through all of those issues as well to make sure you're actually qualified for the visa, not just is the company and is the petition approved.
One thing that pops up a lot of time, the question pops up, is that how can they reject the visa now? Let me explain you guys that There are some non-immigrant visas that does not require immigration to approve for you to approach the consulate. For example, a TN visa don't have to be technically approved. You can approach with the documents. E3 visa is one other kind of visa. B2, B1 visas. There are some other visas that doesn't require USCIS to pre-approve your application. You can directly approach the consulate. But there are some non-immigrant visas, for example, H-1B visa. You have to have the H-1B approved by the immigration. K3 visa, for example, it has to be approved by the immigration before you approach the consulate. What does that tell you is that unless you have the approval, you cannot even apply those non-immigrant visas. So only when you apply the non-immigrant visa in the consulate, which is the Department of State, as Emily has pointed out, they do look into all the aspects again and re-adjudicate your entire application. Emily, you have had experience in visiting Chennai and to visit the non-immigration unit chief there, and you and Rebecca, our other business partner, had the meeting there. Can you explain what exactly are they looking in the non-immigrant visa H-1Bs? What are the statistics that are there right now when people are approaching for the H-1Bs in the consulates? And what should they be careful, or do they need to prepare before, do they need to consult a lawyer for it?
Yeah, what the non-immigrant visa chief had shared with us is many times they have people that are approaching the consulate there for your visa interview, and the questions you're answering are just completely different than what was mentioned in your petition. As far as what your current role is, what your experience is, what technologies or what skills you have is nothing about what was mentioned in the petition or the job you're being sponsored for. You can't even provide any basic information about the company. You don't know how many employees they have or where their offices are located or even where you're working or what the job is that you're going to be doing. Those are reasons why consular officers deny visas in many cases. And it's, a lot of that can be avoided if you just review what was filed. Obviously what was filed has to be accurate, but you need to make sure you know what was filed so that when you're answering your questions, you can have that in the back of your mind to make sure everything is consistent. And then a lot of times, especially with third-party placement or consulting, where you're going to be placed at an end client site at the consulate, there might be something to where the end client has changed since the time the petition was filed and an amendment was never filed. That could be grounds for a visa to be denied. Or maybe the consulate contacts the end client to verify and they don't respond with the information saying that you're supposed to be working there. They have no idea who you are. That can also be a reason for denial of the visa stamp. So you've really got to make sure you have all of your ducks in a row, everything is prepared so that you can be successful with that.
Emily, if people get visas, whether it's F1 visa, or H1B, or all other B1, B2, is there a chance that when they're trying to enter into the United States, they can be denied? And what, in your experience, have you seen when they have denied, and what circumstances they have been denied? Can you give some examples of those things?
Yeah, I think probably one of the top reasons is you misrepresented something at the consulate to get the visa. And now when you're answering the questions at the port of entry, that misrepresentation comes out based on your answers. That alone can be a ground to deny you entry. And then at the port of entry, their job is to make sure that your intention of entering the United States is in line or consistent with the type of visa that you're coming in on. If you're coming in on a business visa and you're telling the officer, oh, I'm going to work in Detroit at company X, that's going to get you rejected at the port of entry because a business visa doesn't allow you to work. It's for business, not for employment. Or if you're coming in on a student visa and you can't even tell the officer where your classes are located, what the address of your school is.
Which city your school is.
Right, and we've actually seen that happen. Or if you can't even tell the officer what an MBA stands for, those are good reasons.
And they're going to MBA.
Yeah, exactly. So you just have to be knowledgeable about the type of visa that you're applying for and what the requirements are, so that your intentions are in line with that type of visa.
And sometimes the circumstances might change, that when you applied for the visa, your circumstances might be different. And now the circumstances have changed and your intentions might have changed. That also might lead your denial in the port of entry. As immigration practitioners, we do see a lot of people getting denied in port of entry because circumstances have changed. For example, if a B2 visa person is there and then the person has been visiting. Now the B2 person is married to a US citizen and she's trying to enter into the United States, and this time her intention is to stay in United States. That definitely her intention has changed. She needs to the intention of the B2 should be only to come in temporarily, but now her intention has changed to permanently stay in the United States. And B2 is not the proper visa, and for them K3 would be a proper visa. So if the intentions change also and the circumstances change, that might be a reason for denial for you to enter into the United States. Emily, I want to move into another topic. We have had this issue on non-immigrant visas getting denied by the USCIS without issuing an RFE. Is there a possibility for it? Have you seen any of them recently?
There is a possibility of it since the September 11th, 2018 memo that came out that gives USCIS the authority to deny any kind of application that's filed if required initial evidence is left out, or if you clearly don't qualify and there's no way that you could qualify. Instead of sending a request for evidence, giving you an opportunity to provide more documents, they can just deny the petition. Now, that's been out there since September. I can say we have yet to have a case that was denied without a request for evidence. I don't think they're applying that for most people, especially if you're filing with an attorney. Most likely everything's being filed properly so that those required documents would not be missing, and there's no reason that they would deny without an RFE.
Emily, I want to move to the I-140, that the priority date. I want to explain what a priority date is. A priority date is the date on which a labor certification has been filed. In some cases, it could be the I-140 without labor certification, especially in the national interest waivers and the EB-1, you don't file the labor certification. So the day the I-140 has been filed is the date that is called priority date. The day the labor certification has been filed, and in some cases, the day the I-140 has been filed. For those cases where the labor and I-140 has both been filed, it's the labor certification date that will be considered as a priority date. Now, that's the date for which you will be considered to be in line to get the green card. So when there is a limitation on the number of green cards to be given, and they will look into who applied the earliest will get the green card, the priority date will become very important. So the priority date is the date on which the labor certification is applied, or in some cases when the labor certification is not needed, it's the day the I-140 has been applied. Now, there are certain circumstances where even if you move from the company which filed the labor or I-140 to a different company, you will be eligible to retain the priority date. Now, Emily, can you explain some of the circumstances mainly where people can retain the priority date if they move from company A to company B?
If your I-140 has been approved for at least 180 days and you are then changing employers and your new employer is going to file a new labor and new I-140, you can port the priority date from the old petition to the new at the time of filing your I-140. The only requirement is that the I-140 must have remained valid for 180 days. If it gets withdrawn after that, it has no impact on your ability to retain that priority date.
So it's 180 days that they should be with the same employer. After that, they can retain the priority date. Is there a time limit under which the second employer has to file the I-140, Emily?
So the good thing with this regulation that came out in January of 2017 that allows for this is that you can keep getting H-1B renewals beyond the 6-year limit with new employers using the same old I-140 approval, even if it's later been withdrawn, as long as it was approved for 180 days. That means you can keep getting I-140 approvals or H-1B approvals with a new employer, keep transferring to other employers. There's no requirement for you to start the new labor or new I-140 right away when you join that new employer. You could do it the next time after the renewal. The reason you need the new labor and new I-140 is so you can ultimately get the green card. You have to have it in place for filing the 485, but up until that point, you can keep relying on the old I-140 to keep extending your H-1B.
I have two questions from the YouTube, Emily. They both are asking the same thing. Srikant and Benedict both have the questions. Is there, for the new quota, they're asking the question whether it's going to be straight denials or approvals, and there's no RFE. That's the question there is. No, there will be an RFE before the denial. Very rare circumstances. In fact, I have not seen a single yet. Our office has not seen, not just in our office, but also when we speak with the people in the YouTube and Facebook and conference calls and blogs. We have not seen a single denial of the non-immigrant visa cases from our clients and the people that we know about. We have not seen a single denial without RFE. So at this point of time, you don't have to fear. There will be an RFE before the denial will be there.
One of the questions on Facebook is, can I travel to my home country while my H-1B is pending with a change of status? So this is someone who's planning on filing in the lottery next week, and assuming that their H-1B is selected and it's still pending, can you travel? The answer is yes, you can, but the real question is, should you travel? And no, you shouldn't while the H-1B is pending, because while it's pending, now a change of status means you want to stay in the U.S. and change your status from your current status to the new status of H-1B. When you leave while that request is pending, they're going to say, wait, clearly you don't want a change of status because you left. So they automatically abandon your change of status request. Your H-1B petition will be approved without a new I-94. You'll have to go visit the consulate, get the H-1B visa stamped in order to come back. So no, I don't recommend traveling while it's pending unless you're requesting consular processing. Even that though, you have to be really careful about when you're planning on coming back, what status are you trying to enter in, especially if you are on F1, when you're coming back in, you have to prove to the officer that the purpose of your entry is to enter on F1, not to work, not to change your status to H1, but you already filed an H1 saying that you wanted to change your status to H1. So you might have a difficult time at the port of entry if you're trying to come back in another status while you have that pending H-1B out there.
Shiva has this question, can we withdraw the H-1B because they got the 221G and apply for the H4 visa? Yes, you can. That probably would be a strategically good way of doing it, to come here on H4 visa. And if you were here before on H-1B, you can always come back on H4 and then apply for a change of status from H4 to H-1B without subject to cap.
Pratusha asks if the change in the order of the lottery, reversing the way they do the lottery, is just for this year, or is it every year going forward? It is every year going forward, including this year.
Next year, we're expecting the reverse of the order of the lottery is, as Emily has said, is going to continue for the next year too. But there is a different system next year that is coming up, where the lottery system, we don't have to file all the applications, only we'll file the selected applications. That's going to be good news for us, so that we don't have to prepare all the applications, and some of which will be rejected in the lottery.
Ravi Kumar asks if someone is considered to be unlawfully present if they're doing day one CPT. It's a very technical issue, if you are doing day one CPT, there is a high chance that you are violating your F1 status. That's different from being unlawfully present. Unlawful presence happens when USCIS says you violated your status. So no, the answer to your question is no, you're not unlawfully present just because you're doing day one CPT, but you are potentially violating your status because you're doing day one CPT, and if USCIS figures it out and they make that decision, then you'll be found to be unlawfully present the whole time you did the day one CPT. So please stay away from those programs that are offering it. It is not worth getting a 10-year bar.
Shalini from YouTube has a simple question. When do we have to file the quota H-1Bs? The quota H-1Bs should be filed between April 1st and April 5th, not on March 31st. It's the day the immigration receives that will count. It is the April 1st. April Fool's Day, April 1st. Remember that, April 1st. That's the day REDDY NEUMANN PC started. There's a reason for it. April 1st is the day the H-1B can be filed, not on March 31st. Now, if the quota is not being filled in the first 5 days, then they will open up for the next couple of weeks until the quota is filled. But believe me, from 2013 onwards, the quota is getting filled every year. So based on that assumption, this year it will be April 1st to April 5th, the first 5 business working days starting from April 1st, which will be this year, April 1st to April 5th.
A couple people on Facebook has asked for any updates on the H4 Ead. No updates as of now. I just checked it and it is still pending. The regulation to get rid of the H4 Ead is still pending with a regulatory review with the OMB. So we won't have any proposal until that review is complete. I do think that we're just now beyond 30 days that it's been pending with them. And because the next round of briefs in the litigation are due April 1st, I believe, that we might see some action potentially the end of this week, maybe, on that. So it'll be shown as review complete on the OMB website, and then maybe a few days later we should get an update in the Federal Register with the actual proposed rule. So that might be coming soon.
Divya has this interesting question. What are the probabilities of HR 1044 to be approved? We have seen this version of the bill in different formats in the preceding 15 years of immigration that I've been in the past 15 years. As much as I want to get it passed, the probabilities are very less for this one to be passed. I would like you guys to keep the effort, try to contact the Congress and write the letters to support this bill and pass this bill. Write the letter to the Speaker, because that's the person who is not keeping it on the table of the Congress. Keep the alternative options. Don't rely completely that this bill will be passed, Divya.
But don't give up on it. I mean, if you think about Dreamers, we had the first version of the DREAM Act in 2008, 11 years ago. And now today, there's a bill that was introduced for Dreamers. So they're struggling too. It obviously takes time. You've got to keep getting support, keep getting stories out there. Submit an op-ed to any newspaper in your area explaining what the issue is to try to get more awareness of it, and then you might see some more traction.
For those people who don't know what this HR 1044 is, that this takes the discrimination on Indians and Chinese on the employment-based immigration. What practically does is it removes the per country quota. Everybody will be treated equal in the employment-based immigration. Nobody will be above and below. And because right now we do have a limitation that a country cannot get more than 7%, Indians in particular get discriminated on the employment-based immigration, and to some extent Chinese nationals. So if this 1044, they take the per country quota out, every person will be treated equally. Those people who have been waiting in line for 10 or plus years will be able to file the adjustment of status. If the 1044 bill is going to go through, it is expected that the priority date for the Indian national will come to 2016. And the following year, it probably will be 2017 or 2018. So practically the green card time, waiting time, will cut down from 150 years based on some people's expectation. According to us, it's 106, but some people it's 150 years. The time will cut down to 3 years for the Indian nationals.
Santosh has a question he's got. Is OPT expiring July of this year, and wants to know if a CPT college starting in August is a good option to for that gap. No. These day one CPT colleges are not good options at all. They could cause you to be barred from the US. If your H-1B is being filed this year and it's selected, you requested a change of status, your OPT will be extended to September 30th. You won't need to fill the gap, and you can make sure your H-1B gets approved by October 1st by filing in premium processing or upgrading to premium processing once it's selected. It's very helpful to have your H-1B approved before October 1st so you don't have to worry about what happens after the cap gap ends.
It's an interesting question from Balakrishna from YouTube, Emily. Saurav Prakash from YouTube, Emily. Does he need to file the premium processing right now? Can he choose to convert the premium processing on May 20th?
Yes, you can. You can wait until you know you've been selected and then upgrade. There's no problem with that.
One thing that I may have, Emily, in this one is that what if this administration comes and tells that we're not going to take any more premium processing?
You never know.
You
I
never
would
know.
be surprised that if they would do that, given that they've already said June is when we're going to allow it for other petitions. I don't think they're that heartless. They're pretty close, but hopefully it will remain available for some time to allow you to upgrade.
There's a lot of questions on the premium processing. Let me clarify. Premium processing is allowed for almost all applications except only one application. That is, if you're filing in the new quota, and that too, if you're filing in the consular option. In the new quota for change of status, they can still do the premium processing. Only in the instance of the consular processing in the new quota, you cannot do premium processing. So premium processing is allowed for extensions, premium processing is allowed for transfers, premium processing is allowed for amendments, premium processing is allowed for new quota with change of status. So only premium processing is not allowed is for the new quota when you're filing for the consular processing.
One of the questions that I get a lot on the blog right now is what's the difference between change of status and consular processing? What do those mean? A change of status is for someone who's currently in the United States and you are requesting USCIS to change your status from your current visa category to the new visa category without the need to travel or obtain a new visa stamp. So if you're in the US and you'll be maintaining your current status through September 30th, you are eligible for a change of status without having to travel. So if you get the change of status approved, you don't have to travel and you don't need a new visa stamp. Even if your current visa stamp is expiring, you still don't need a new visa stamp. The visa stamp is only necessary when you are entering the US. It opens the door to the United States. That's what the visa stamp is for. Once you're in the US, it's your I-94 that determines how long you can stay. And when you're doing a change of status, you're going to get a new I-94 on your approval notice that extends your stay for up to 3 years if it's an H-1B approval notice. So that becomes your new I-94. One thing I want to point out that people get confused on is most people now, when you're entering the US, the I-94 you get is online. You go to the CBP website, enter in your passport information, and you print your I-94. But when you're filing with USCIS and requesting a change of status, your new I-94 will only be on your approval notice, your I-797 approval notice. The one online does not get updated. So just don't get worried if you have your approval notice and later you checked online and nothing changed there. They don't change I-94s online based on one issued by USCIS.
Narasimha has this interesting question. He's an Indian national. his company has positions that are eligible for EB2 and EB3. Which one is a preferential one to file under the current circumstances? That's a very tough question. We have seen the EB2 and EB3, in particular for Chinese nationals, moving backward, forward, backward, forward, and backward and forward. And now recently for the Indian nationals, it's going to be backward and forward. I'm not telling you what to do, but if I were you, I would probably prefer EB2 though. There are different reasons why. One is that the unused green cards of the EB1 will be given to the EB2 people. And
there are any.
If there are any, yes, that's right. In the past 2-3 years, there are none. But previously, from 1992 to 2016, the unused EB1s were all given to the EB2 cases. So the number of people who got the green card from EB2 for Indian nationals for EB2 is very high. That's one reason but if that's one reason. The second thing is that to convert EB2 into EB3, you can use the same labor certification if your employer is willing to convert the same without filing another labor. You can convert into EB3 at any point of time. So when the priority date becomes current for you in EB3, you can convert and file the adjustment of status without filing any labor certification. These are the two reasons why I personally feel that EB2 is better than EB3. But if any other lawyer or any other person is telling you that EB3 is better, I will not contradict them. I mean, they are right in their own way, Emily.
Yeah, I mean, one thing you could consider, if the labor certification qualifies for EB2, it also qualifies for EB3, you could actually file 2 I-140s at the same time. One in EB2, one in EB3. The only thing you have to be aware of is only one of them can be premium processed because you only have one original certified labor certification. So if you want to do premium processing for one of them, the original labor certification should go in that petition, and then the other one would have a copy filed in regular processing, and that way you don't have to choose.
Both you have.
You're ready to go whenever
they are. You don't have
current.
to do it. So use the same labor certification, file EB2. But I've noticed that, Emily, is that when I have used the same labor certification, when the EB2 is already approved and I'm filing for the EB3, no problem. Mm-hmm. I'm able to do premium processing also in EB3. But of course, there are some situations where I've noticed that the officers did not consider the premium processing. That's clever option that you have, Emily.
Shiv has an issue. He currently is working on H-1B but hasn't been paid for 3 months and wants to know how he can file a transfer in this situation. Now, the regulations allow a 60-day grace period for you to file a transfer. So if you were at the 2-month mark, you could have potentially filed a transfer. Now that you're at the 3-month mark, from your situation, I understand that you are actually working, it's just your employer is not paying you. You might have to file a complaint with the Labor Department and include documentation of that when you file your transfer, so that USCIS will see that it's not your fault. It's not that you stopped working. You're still employed by that company. They just haven't paid you, and it's their violation, not yours.
Ragini has this interesting question. Her I-140 has been denied. What's the best course? Motion to reconsider or refile the I-140 using the same labor certification? First, we need to understand why the I-140 has been denied. That's the number one thing that we have to determine. Second thing is that in what stage you are in on the H-1B. If you are at a stage where you just want to get your H-1B extended, there might be reasons why you may want to just file an appeal and prolong it for a long period of time. But there are some times where you want the I-140 to be approved. It's not just you want it to be pending. Then at that point of time, you may want to choose to refile it again, because motion to reconsider or motion to reopen or appeal is taking a long time right now. If you reapply, you may do premium processing. You may do, and sometimes they may object it. And if you do premium processing, you will get the adjudication done quickly. But first thing is that why was the I-140 denied need to be looked into very carefully.
Krishna has a really good question. So he currently has OPT and he has the option of getting the STEM extension until 2021. So he wants to use up all of his STEM OPT time and still file in the H-1B lottery but request consular processing so that he can use up his OPT time and then later convert to premium processing. But his real question is, what if he wants to then switch companies? That is the difficulty. So if you get your H-1B approved in consular processing, just having that approval does not mean you're counted in the cap yet. In order to be considered counted, you either need to enter the U.S. in H-1B status, such as getting a change of status approved, or get the visa stamped. So if you haven't gotten the visa stamped or entered the U.S. in H-1B status, you may have difficulty transferring that consular processing H-1B approval to any other employer and may have to go through the lottery again.
When is the lottery conducted, Emily? Repeated question from Aditya from YouTube.
So they're going to take all petitions that are properly filed between April 1st and close of business on Friday, April 5th. Last year, they announced that the lottery was done already on April 12th. It happened pretty fast. So right away, they're going to take all those petitions. They assign every single one of them a random number, computer generated. They run the lottery, and then within about a week, they announce that they've run the lottery and they start sending receipt notices out. So I'm going to say probably around April 12th again, we might get the notification that the lottery has been conducted.
Interesting question coming here from Balakrishna from YouTube. He's asking the question, do you recommend filing premium processing for an amendment? The general answer would be no. This is the only time I do not recommend premium processing. It's an amendment. And why is that? One of the reasons is that, let's say, for example, you moved from Florida to California and you file an amendment. And then you file a premium processing. They may issue an RFE, they may sometimes deny it, then you have to file it again. If you just don't file the premium processing, the case will be pending for a long period of time. Let's say, for example, you move out while the H-1B is pending from California to New York, you file another amendment or amendment plus extension. So you avoid the circumstances of facing an RFE or a denial because it's going to come faster if you do premium processing. Believe me, this is only circumstances. REDDY NEUMANN PC might not recommend premium processing. All other circumstances, we strongly recommend premium processing. Now, having said that, Balakrishna, one other thing is that if by any chance your I-94 is expiring though, and this is an amendment plus extension, or if it's an I-94 is expiring, absolutely you should go for the premium processing. Don't wait. Get the decision earlier. Because if the I-94 is valid and you get the denial, you get RF, you have multiple options. But if I-94 expires and you get the denial, you will be very limited.
Yeah, speaking of that, Sharath has a question. How soon should someone leave the country if their extension is denied and the I-94 has expired at the time of the denial? So the denial is going to put you immediately out of status and you begin accruing unlawful presence starting the day after the denial was issued. So certainly you have to make sure you don't accrue 180 days of unlawful presence, because then you're going to trigger the 3-year bar. Now, does that mean you're okay to stay in the U.S. for 179 days? Not really. You're out of status and unlawfully present during that time. There is no grace period, and we also have this NTA memo that says USCIS can issue a notice to appear to anyone where the petition has been denied and the I-94 has expired. Now, as of right now, that only applies to I-485s and I-539s when we're talking employment-based. So if you have an H-4 spouse whose denial happened because yours was denied, your spouse could end up with an NTA if you don't leave within 30 days. So I would generally recommend not staying beyond 30 days. Understand that even if your employer files a motion to reopen or an appeal, that does not provide you with work authorization or status until it's actually successful. So if you decided to stay and wait and the motion takes 6 months, you've been out of status for 6 months and unlawful presence still continues during that 6 months. Now that we have premium processing, You're in a much better situation to quickly exit the U.S., refile the extension, or file a transfer to another company requesting consular processing, do it in premium, get the approval in 2 weeks, get a new visa stamp, and come back. That's going to probably be much better than hanging around in the U.S. waiting and potentially accruing unlawful presence to where you're not eligible to come back.
Tulsi has this question. The kids have filed H4 for both, both the parents. What if they withdraw one of the H4 right now? Will it cause the kids to go out of status? Why worry about withdrawing it? Just keep it there. If they have both I-94 valid, the latest one is the one that will count. So whichever is approved the recently will count the most though. I wouldn't bother withdrawing one of the H4. No, any reason to withdraw it? No.
Smita has a question. She currently is working with Company A on her H-1B and wants to know if she files a transfer to B and it gets denied, does that have any impact on the current company's H-1B? No, it doesn't. Now, if you've switched companies and B's get denied, that denial puts you out of status. But if you stayed with Company A and then B's gets denied, it has no impact on you or your current H-1B or your current company.
Mandala has this question. Can the FDNS visit happen for the amendment, and is there any timeline? There's no timeline. FDNS can visit for anything. FDNS can visit for consular processing. FDNS can visit for the amendment, extension, transfer, anything they can do the FDNS visit. We have noticed that recently a lot of FDNS visits have been occurring, particularly if your company is a H-1B dependent company. That means that the total of 25% or more of your workforce is H-1B. We have noticed a lot more FDNS visits. If your company is a consulting company placing individuals at third-party location, that's a big indication that the FDNS is visiting a lot of these places.
Kishore has a good question. If you're entering back into the U.S., say you took a vacation, and your I-94 gets cut short compared to your petition validity because your passport is expiring before your petition is expiring, what do you need to do in that situation? So you do need to make sure that when you're entering, first thing you do is check your I-94 online to see what the end date is. And if you see that it's shortened because your passport is expiring, understand that that is your expiration date, not the one on your petition. It's the most recent I-94 that controls. That's the last action rule. So now you have this new expiration date. In order to extend beyond that date to get the rest of your petition validity, once you have your passport renewed, you can go out and come back in again, get a new I-94 that should be for the full period now because your passport is valid long enough. Or you have to file another extension with USCIS, which is going to, is kind of pointless because you don't know if it'll be approved. In this day and age, you might have an RFE. All of those same issues might come up. So travel is usually the best way to fix that once you have the new passport.
Let's go with the last question, Emily. It's almost 6 o'clock today. For those people, one question that is an interesting question that came out here is from Kumar. Does the lottery help the master's student people? The new lottery system does help the master's student. Does it help?
Yeah, about 15% more chance of being selected because of this new lottery system if you're in the master's
So if the
cap.
same number of applications were being received last year and the same number of applications are received this year, your chance of getting into the lottery, if you do have a master's degree from an accredited nonprofit university, your chance of getting selected in the lottery is 15% higher than the last year. So yes, it definitely helped the master's students, and it at the same time, remember that this 15% extra is getting cut off at another place, which is the bachelor's. In other words, those extra things that are getting to the master's, if you have a bachelor's degree or you're outside, you got the master's outside this country, your chances are going to go back a little bit because this extra 15% master's people come in. For those people whom we couldn't attend, please check our other YouTube that we have given. We do have a blog, Immigration Girl, please follow it. We do have a daily conference call that's free for you to attend and ask live questions. I mostly will be there, and sometimes some other lawyer will be there in there. If you want to make an appointment with me, Emily, or any of our colleagues, they're all competent colleagues in our office. You can go to rnlawgroup.com. You can make an appointment with any of us. Emily?
All right, and yes, I will be updating statistics on the progress of receipt notices and lottery and chances of selection and all of that.
Every working day.
So
Once the lottery system goes on, she updates it when it comes in. So a lot of people watch that.
yeah, so you can get that information at immigrationgirl.com.